A new court filing by the U.S. Department of Justice reveals attorneys for the federal government are arguing that the nationwide ban on marijuana consumers owning firearms is constitutional and should remain in place. The case, Green versus Garland, involves a Pennsylvania prosecutor who uses medical marijuana but wants to challenge federal gun laws that prevent marijuana users from possessing firearms. And this comes after a Texas court ruled cannabis users cannot be barred from owning firearms. Let's go and bring in Chief Legal Analyst Khalif Rose to break down exactly what we're seeing here from some of these conflicting laws with the states.
Conflicting is an understatement, and so this is, this takes me back to when I taught law school. For sure, what I can tell you is this would be an excellent exam for the end of the year, specifically because you're talking about constitutional protections. You're talking about, well, what type of history do we have that shows that we don't want these type of folks having firearms? So, and then you got some curveballs. You have a prosecutor that's bringing this claim. Most of the time, you don't see a prosecutor bringing a claim as a person that's challenging issues at the federal government. So you got two basically prosecutors going at each other. It's a lot of intriguing parts. So start with this prosecutor in Pennsylvania, his attempt at saying, look, they have medical marijuana in Pennsylvania. I carry my medical marijuana card, but as a requirement for me to get this card, it's saying that I won't be able to own a firearm because they cross-reference my name and show that I am an active user of marijuana. And that even though the state legalizes, the federal government's argument is that you are, and they said in their complaint, you are consistently violating federal law every time you use it. And they list a number of reasons as to why they don't think it's a good idea for a person to have a firearm and smoke weed. Specifically, they say it deters you from making right decisions, that you're unaware of what you're doing. I mean, they list a number of things, but he shoots back and says, I don't think that there is the science to support what you guys are saying, and the Constitution doesn't support it. And then you get to the Texas case, which their court down there in the Court of Appeals basically said, we don't have a history of doing that. And why do they keep saying we don't have a history of doing that? The Supreme Court most recently, and Clarence Thomas is the one that's spearheading this approach, is saying that the new angle when you look at these types of cases is, do we have a historical approach to not wanting folks, these type of people, to have firearms? Domestic violence victims, yeah, we have a history of not wanting that. But drug users, is there history there? The courts have said no.
Yeah, the connection on this type of thing. But, you know, you're talking about the Supreme Court with Clarence Thomas. Is this something that is headed to the Supreme Court?
It should, and it will. I mean, anytime you get a conflicting view of opinion, anytime you get an issue that they already have tipped their hand that they want to hear, they're just waiting for the right case. I mean, and so him making that address that we need to address and figure out, A, do we have a history of not wanting these types of folks to have firearms? And if we don't, you just need a case like this to be able to show, hey, it's right for us to address it. And let's not even mention who else this addresses. This addresses Hunter Biden. Hunter Biden just was convicted on this very same thing. He was a drug user, attempted to get a firearm, got a firearm, and then what happened? They convicted him because he was a possession of a firearm while being someone, not a felon, but someone that was actually just using drugs. And so I think this one goes to the Supreme Court. And if I had a crystal ball, I think the Supreme Court says that if Pennsylvania is attempting to stop him from using marijuana and having a firearm, they are wrong because we don't have a historical analysis that shows that. And when they say history, they're talking about a specific case that's shown that in history that we want to deter these type of people. And I can't think of anything like that. So when you go through the analysis, it seems like the Pennsylvania guy will proceed. Prevail. I think the Texas guy, they got it right. And if it makes its way to the Supreme Court, I think the Supreme Court 100% follows their agreement, specifically this Supreme Court, who is increasing gun rights as opposed to attempting to limit them.
Yeah, and it's certainly a case that we'll keep following, or both cases that we'll keep following with this one. All right, Chief Legal Analyst Khalif Rose, thanks. Let's get